A very good day to all of you. For the past few days, all social media platforms, professional circles, everywhere, the talk was about the recent judgment of the Gujarat High Court relating to the construction industry. We will try to understand what the High Court has held. As per serial number 3 of notification 11/2017 and various subclasses, whenever any construction activity is undertaken in a land and the land is also transferred to the buyer for a sale price. The notification provides one third of the total sale price will be deemed as the value of the land and GST will be payable on the remaining two-third value. For example, if an apartment is sold for 60 lakhs, one third, that is 20 lakhs, is deemed as the value of the land, that is the undivided share of the land, and the remaining 40 lakhs will be treated as the value of the supply, which is leviable to GST. So on that, GST will be calculated. In the case before the Gujarat High Court, it was construction of a bangla in a vast stretch of the land. So even though the land was very huge, the constructed area of the building, the bangla, was comparatively smaller. So the huge value pertained to the value of the land only. But they were permitted to deduct only one third of the total price. On the remaining two thirds, they were liable to pay the tax. Actually, the value of construction will not be equal to two thirds. So that was the case where they have filed a writ petition before the Gujarat High Court. And some other writ petitions were also filed against the advance ruling authorities' decisions where the plot development, there also GST was demanded after allowing one third towards the land value. So the court came to the conclusion finally, this one third is a deeming fiction. So any deeming fiction will come into operation only when no other alternative method is available, that too at the option of the taxpayer. So a deeming fiction cannot be forced on the taxpayer. When the value of the land is separately available, agreed between the parties, there is a separate value for construction and there is a separate value for land, then that has to be given preference rather than imposing that one third will be treated as the land value. So what will be the consequence of this decision? Basically, all these sales, apartments and all. So we should also note another fact. Even though in that particular case, it was argued, this is a case of a bungalow which is being built on a vast stretch of land and it is not a case of an apartment. We can't say that this judgment will apply only for bungalows and not for apartments. So even for apartment construction also, the ratio of this judgment will apply. That is the first point which we have to note. Secondly, basically there are two types in which the sale of apartments are undertaken. In some places like Tamil Nadu, there will be a separate sale deed for transferring the undivided share of the land. And there will be a separate construction agreement. Suppose I'm purchasing a flat for 60 lakhs. There will be a sale deed for, let us say, 10 lakhs for conveying the undivided share of the land. And for the remaining 50 lakhs, there will be a construction agreement with the builder. The sale deed will normally be entered into based on the guideline values prescribed by the government. Even though it may not in all the cases match with the market value, mostly the sale deed will be for the guideline value fixed by the government. In some places, like I understand from Maharashtra and all, once an apartment is sold, it will be registered for the entire value. There will be no breakup between the land value and the construction value because the land will be collectively held by the society. There will be no separate land value. It will be a lump sum price. So now, this judgment will be helpful in the first type of the cases where separate values are identified for sale of land or undivided share of the land on the one hand and the construction value on the other hand. Wherever the sale deed value for the land or UDS land is going to be more than 1/3 of the total price. Let us say 60 lakhs is the flat value, where the land value itself is coming to 30 lakhs. So the remaining GST will be payable only on the remaining 30 lakhs. So as per the High Court, once the land value is available, you should not take this 1/3 option. It cannot be forced on the taxpayer. So wherever the land value as per the document is more than 1/3, this judgment will be beneficial. And wherever the land value as per the document is less than 1/3, now the question is whether still they can go for this option, or once the separate value is available, we have to go only by that. This question has not been specifically addressed by the High Court, but going by a reading of this particular judgment, opting of that 1/3 will be possible only when the land value is not available separately. That seems to be the ratio. So in the same example of 60 lakhs, where the land value is 10 lakhs, whether GST has to be paid on the remaining 50 lakhs, or still they can opt for 1/3 option and pay only on the 40 lakhs is $1 million question. So if we go by the ruling, it appears that once the separate land value is available, that has to be accepted. So in the given example, 60 lakhs purchase price, 10 lakhs is the UDS value, GST will become payable on the remaining 50 lakhs. So this way, wherever the land value as per the document is going to be less than 1/3 of the total sale price, this judgment is not in favor of the taxpayers. That is the second point which we have to note. Now, if separate sale price is not available, is 1/3 is the only option available? No, according to the High Court, if separate value is not available, then the value of supply of goods and services has to be identified. The land value has to be excluded. For that, the taxpayer can either adopt 1/3 of the total price as the land value and exclude it, or the construction service value, the value of supply of construction service, can be determined with reference to valuation rules. So if we go to the valuation rules sequentially, maybe based on rule 30 or 31, if cost of construction can be arrived at, which is quite possible. So even though the sale price is a single price, no breakup is available between the land price and the construction value. Now, the taxpayer will have two options. Either he can treat 1/3 of the value as the land value and pay GST at the 2/3 value, or he can determine the value of the taxable supply, that is the value of the construction service, based on cost of construction plus 10%. So based on that, the value can be determined. On that also, the tax has to be paid. So this option will definitely be beneficial for the taxpayers, because cost of construction, normally what happens, the sale deed is entered for the based on the guideline values, and the entire the difference between the market value of the land and the guideline value is loaded to the construction value. That is how it happens. So the actual cost of construction will be somewhere around 2,000 per square feet to 3,000 per square feet, depending upon the materials used. So based on that also, the value can be arrived at. So the issue, or as far as the plot development, that is sale of developed plots, whether it is first of all liable to GST or not is a basic question. On that we have various advanced rulings on both ways. The court has not said that the sale of plot is not at all liable to GST. There also the question was whether the compulsory mandatory deduction of 1/3 towards the land value, that is not correct. That is the ratio of the judgment. So otherwise, whether sale of a developed plot by itself would be liable to GST or not, that issue has not been considered by the High Court, because that was not an issue before the High Court if we go by the reading of the judgment. So definitely a path-breaking judgment, especially the construction sector after the 2019 amendments has become highly complicated, and the courts have started interpreting the provisions, and this is one of the very landmark decision as far as this particular area is concerned. Thank you all.